Your landlord just walked into your apartment without telling you. Or they kept your entire security deposit and gave you no explanation. Or they found out you complained to the city about a broken heater, and now they're threatening to kick you out. Here's something most renters never find out until it's too late. All three of those things are illegal. Not just wrong, not just unfair, illegal. And landlords get away with it constantly because most tenants don't know their rights. By the end of this video, you will. We're going over the most common things landlords do that they are not actually allowed to do, and what you can do about it. Stay with me. Over 44 million households in the United States rent their home, and a huge number of them are dealing with landlords who are crossing legal lines every single month. Let's go through the big ones. Number 1, entering your home without notice. Here's something that surprises a lot of people. Your apartment is your home. Even though someone else owns the building, while you are renting it, you have the legal right to what the law calls peaceful enjoyment of that space. What that means in practice is this: your landlord cannot just walk in whenever they want. In almost every state in the country, landlords are required to give you advance notice before entering, usually 24 to 48 hours. And in most cases, that notice has to be in writing. There are very limited exceptions. A genuine emergency, like a burst pipe, flooding the building, or a fire, yes, they can come in. But I want to check on the place, or I'm bringing a contractor by, does not count as an emergency. If your landlord is letting themselves in whenever they feel like it, with no notice, that can rise to the level of landlord harassment. And in some states, you can actually sue them for it. What should you do? Document everything. Every time they enter without notice, write it down. Date, time, what happened. Send them a text or an email asking them to give proper notice going forward. That creates a paper trail. And if it keeps happening, you may have the right to break your lease without penalty, depending on your state. Number 2, keeping your security deposit illegally. This one happens all the time. You move out, you leave the place in great shape, and weeks go by with no deposit. Or you get a partial amount back with some vague list of deductions. Here's what the law says. Most states require landlords to return your security deposit within 14 to 30 days after you move out. The exact number varies, so look up your state's rule. But there is a hard deadline, and missing it has consequences. If the landlord is keeping any part of your deposit, they are typically required to send you an itemized list, in writing, explaining exactly what they're deducting and why. No itemized list? In many states, they automatically lose the right to keep any of it. Now here's the part landlords really don't want you to know. The law specifically says they cannot deduct for normal wear and tear. What does that mean? A few scuffs on the walls from furniture, carpet that's worn down after years of normal use, small nail holes from hanging pictures. That's normal. That's expected. They cannot charge you for it. They can charge for genuine damage, like a hole punched in a wall, or a carpet destroyed by a pet. If your landlord kept your deposit illegally, you can sue them in small claims court. You don't need a lawyer. Filing fees are usually under $100. And in many states, if a judge finds the landlord wrongfully kept your deposit, they can award you 2 or 3 times the deposit amount as a penalty. So that $1,500 they kept could turn into $4,500. Number 3, refusing to make essential repairs. Your heat went out in January. You've sent 3 texts, nothing. Your landlord is ghosting you. That's not just bad customer service. That may be an illegal violation of what's called the implied warranty of habitability. Every residential lease comes with a legal promise, even if it's not written down. The place you're renting must be livable. That means working heat, hot water, no major pest infestations, no dangerous structural problems. and working locks on the doors. If your landlord refuses to make repairs that affect habitability, you have options. First, and this is critical, put the repair request in writing. Text, email, written letter. Something with a date stamp. Never just call. If they still don't act, depending on your state, you may be able to withhold rent until the repair is made, while putting the money into an escrow account, not just pocketing it. Or you can repair and deduct. Hire someone to fix it yourself and subtract the cost from next month's rent. Most states cap this at 1 month's rent. Or in serious cases, you may be able to terminate your lease early with no penalty, because the landlord breached their end of the agreement. Number 4, retaliating against you. This one is big, and it might be happening to you right now without you realizing it. Let's say you complained to your city's housing department about your building's conditions, or you organized with other tenants, or you told your landlord you knew your rights. And then, suddenly, they're trying to raise your rent, or not renew your lease, or they're finding reasons to write you up. That is called landlord retaliation. And in most states, it is illegal. The law protects tenants who exercise their legal rights. If your landlord takes negative action against you within a certain window after you made a complaint or took protected action, in many states that's 60 to 90 days, there is a legal presumption that it's retaliation. The burden then shifts to them to prove it wasn't. Document the timeline. Keep every communication. If the retaliation involves an eviction attempt, you can raise retaliation as a legal defense in court. Number 5, self-help evictions. This one is the most extreme, and it still happens. A landlord decides they want you out. So instead of going through the legal eviction process, which takes time, they decide to speed things up themselves. They change your locks, they remove your front door, they shut off your electricity or your water. They throw your belongings onto the street. All of this is illegal, everywhere in the United States. There is no state in this country where a landlord can remove a tenant by force without going through the court system. None. This is called a self-help eviction. And if it happens to you, call the police immediately. This is not a civil matter you have to wait on. You have a right to be in that home until a court says otherwise. In many states, a landlord who does this can be sued for damages, attorney's fees, and punitive damages on top of everything else. So let's recap. Your landlord cannot enter without notice. They cannot keep your deposit without a written itemized reason. And they cannot charge you for normal wear and tear. They have to keep the place livable. They cannot retaliate against you for knowing your rights. And they absolutely cannot lock you out or cut your utilities to force you to leave. The law is on your side more than you think. You just have to know it. If this video helped you understand something you didn't know before, hit that subscribe button. Every week on this channel, we break down real legal situations in plain English, so you can protect yourself without spending $1,000 on a consultation. Drop a comment below. Has your landlord ever done something that felt wrong to you? I read every single comment, and your question might become the next video. See you next week.